tell you about the purpose of this meeting, of this session, and what we would like to get as a result of this session. This is a provocative name. Does Russia need a special way for cryptoeconomics? Our center is looking into the international standards and modern trends in various spheres are adopted and how our legislation is in line with these standards. Everything what is related to cryptocurrencies, ACOs, so is based on some global trends starting from 2013. One of the first countries which started this process was the United States, Japan, followed by the European Union. The main tasks and risks were already identified, and now they're trying to develop a regulation, a soft or explanatory nature, and tough regulation deals with identification of clients of crypto stock exchanges and crypto pockets, but all the trends are quite clear. Today we would like to show and to tell you what is going on in the world at large, what is happening in Russia and will be happening in Russia, and we will need to try to understand do we stick to the common criteria definitions in this new sphere as crypto economy. Anatoly Ivanovich has joined. Tatiana Dmitryevna Volovaya, representative of the international organization, minister. Tatiana Dmitryevna, we have been working for 1 year already on issues of crypto standards, cryptocurrencies in 5 countries of the Eurasian Economic Union. This is the union who is doing the right thing in order to show standards of regulation, in order of bringing them in harmony with the international standards. Within the framework of the Eurasian Economic Commission, a lot of being done in terms of what should be regulated and how it should be regulated. Various business processes in crypto mode, they are of advisory nature, which allows countries to adapt them. It provides for basis, definitions which can provoke some disputes which appear in practice. So I believe from a methodological point of view, this is the right way to follow. Deputy Minister of Finance, Mr. Moiseev, we have been working for quite a while on forms of control, measures of control, and Alexei Vladimirovich from Ministry of Ministry of Finance is dealing with the financial digital assets. We have several bills, drafts on crowdfunding, which deals with the cryptocurrencies. This is a systematic issues which used to be applied in the future. Mr. Aksakov, representative of another branch of powers, legislative power, State Duma, he is dealing with the financial assets, including digital financial assets. But 2 days ago, we thought it would be in February or March. Probably there would be several readings of this draft law, and probably he will provide his own position on that. And Vladimir Nazarov, we know each other for quite a while. Vladimir is the head of the NIFI, and we get acquainted in the context of the work on digital financial assets. We provided our proposals, colleagues positively responded to that, and I believe now we have a common vision regarding this sphere. I also would like to say that business also takes part in this meeting, Pavel, Sergei, Piotr, on the left side of the table. And probably we have a representative of the OECD, our international expert, Iota. She is author of the first report, which was produced literally yesterday, and we would like to know what OECD thinks about these new processes and risks and how countries responded to that. As my colleague has just said, we will have an interactive session. In fact, we will discuss 7 issues, and on these issues all the speakers would provide their own opinion, and audience would also take part in this discussion. So please show again the link, internet link or QR code. Now we are coming to the first issue. The first, what do you think? What is the first risk which regulators identify in cryptocurrencies? 3 options. Cryptocurrencies would replace normal or fiat money. It would be used for money laundering or construction on financial pyramids. The European Central Bank and the United States, this is what they saw in the cryptocurrencies. Alexei Vladimirovich, what do you think about this? What would be the right answer? As far as I remember, we discussed this issue recently during the G20 meetings in order to provide some recommendations for the countries in order to ensure financial stability. But it deals with 2 aspects: prevention of money laundering and protection of the interests of consumers who used cryptocurrency. I believe the first element is the right thing. Financial pyramids remains a very difficult issue. So far we overcome this problem and we don't have any problems with that. Tatiana Dmitrovna, we know that now there is a lot of work on harmonization of cryptocurrencies among the Eurasian economic member states. What are the main features in this? I agree with what has been said. The main risk is the money laundering, but from the point of view of our union and maintaining the economic space for us, the main risk is differences in regulation, because in the Eurasian economic space, when we're trying to create a common financial market and a common policy, the national regulation on cryptocurrencies would be different. That would create a lot of risks for these integration processes. We will see a lot of barriers and shady schemes in order to circumvent the national regulation. That is why for us it was very principal thing to create common approaches among all 5 member states. Anatoly Gennadievich, question to you. We know the draft law on digital financial assets makes reference to money laundering, and at the same time we cooperate with Rosmonitoring, and we never heard from them that they are going to amend Article 115 in order to identify clients and accounts on transactions on new hubs on cryptocurrencies. Is it so? Do you have any plans in this regard? Please push the button. Good afternoon. As to the parts of the draft law which describes the use of digital financial assets in terms of identification and preventing money laundering, everything is there. And it's quite clear that the issues that are outside of these draft laws. I mean, crypto industry is wider as it is described in our draft laws. That is why I would like to say that there are some lagoons or niche that we need to cover, to deal with, and practically we agreed with Alexei Vladimirovich that we will launch such kind of a work. At the recent FATF meeting, we elaborated the definition of these virtual tools, as they call it, and now national member states face the task to discuss, to address this issue on, or to set this issue in the national legislation. I mean, DFAs and prevention of the money laundering. So these are the results. So it's good. Just a year ago, we practically never heard something about money laundering. We heard about risks of replacement of fiat monies or currencies, and we heard that this is the protection of consumers. We are working very hard in an international area on crypto economies, and Ivan will provide the correct answer and provide some comments to justify this. Good afternoon, colleagues, speakers, and audience is right. The first risk to be identified by international organizations and countries is money laundering. European Central Bank mentioned about this in 2013. FATF mentioned this in 2014, providing good classification of cryptocurrencies and virtual currencies, which are used by many OECD countries. But however, along with the risk of money laundering and terrorism funding, countries identify three more issues. This is undermining of the taxation base, violation of the rights of consumers, and violation of the law on securities. These are four risks which are regarded by the countries, and starting from 2013, they have started to understand that this is 1 billion market and it should be taken into account. They started to regulate. They started to regulate these four risks differently, but they apply the same approach. They provide explanations on some issues or provide several amendments to the existing legislation, which provides better understanding regarding how to deal with the taxes on cryptocurrencies. In 2018-2019, we will see just roots of these draft laws. So far, they are regulated by the way of explanation or amendments into the existing legislation. Some rhetoric question. The direct prohibition in Korea, is it a soft regulation? ACO, I mean. South Korea have big crypto mines. And recently, the Central Bank of Korea provided some explanations how banks could work with cryptocurrencies. That allows these banks to launch transactions to exchange fiat currencies for cryptocurrencies. These are explanations which are needed to regulate this market. The protection of ACOs, that was a quite hectic decision because of the fear that the telephone were practically burning, and people would like to know what the ACO is about and could they invest in that. And the Korean authorities admit that that was the wrong decision in terms of the cryptocurrency regulation. Now let's move to another issue which is quite logical. Could we monitor chains of cryptocurrency transactions? No, possible, but not for all cryptocurrencies. Possible for all cryptocurrencies because it is based on blockchain. Alexey Vladimirovich, you will be the first victim. What is your opinion on that? What would be the right answer? I believe anonymous of cryptocurrency transaction is illusion. So it's possible. Possible for everything. For all currencies. Vladimir Stanislavich. Vladimir. In fact, indeed, transaction could be monitored. So there is a register which has everything. So you can monitor this transaction, but the level of anonymity of this monitoring, so to identify who and what kind of a transaction it was. So my answer, yes, because all transactions are registered. For all cryptocurrencies or not? I would say that for all, even Bitcoin, even we admit that there is a high level of anonymity, but the the nature of this transaction could be closet, but the transaction could be monitored as transaction. Business would like to comment. In fact, not at all. Some currencies allow to reject if you give all the keys, but you can prove that this transaction was done by you. There are some currencies that provide for such features. Anatoly Gennadich, you were right. Vladimir, I believe, was right. In terms of identification of chain of transaction, no problem. But regarding anonymity, there are some systems which are used currently, so to ensure the maximum anonymity of those who are involved in this process, depending for whom and which technologies are used. If some individual transaction which is monitored by specific countries, yes, the answer is no. But if some people are specifically involved in monitoring of these processes, it is possible. If you have access to all computers of all those involved in these transactions, you can easily identify them. In the case of such cryptocurrencies as Monero, you cannot identify the link between even two participants. You can do it if you have all the keys, if all the participants provides the information about their part of the transactions. These are technicalities, but if one dictates to open this transaction, of course, I would be obliged to do so. Tatiana Dmitrievna. I believe that now there are some cryptocurrencies which could be fully anonymous, but I believe this is a temporary provisional processes. Each anonymity would find its own hacker, and at this point maybe it is yes, but in some point of time, maybe in a month's time, this problem would be overcome by hackers. So everyone would invent something new, and someone invents something to break this something new. So these are the results of the answers. So you are creating the trends. So the audience was right to a great extent, as the as the podium. I heard, yes, it's possible, but there are some cryptocurrencies which are still protected to a greater extent as compared with other cryptos. Possible, but not for all cryptocurrencies, and I will ask my colleague to explain why this is the right answer. It is based on the report of the European Parliament and Europol. According to this data, there are some cryptocurrencies which use system uh, closet system like replacement of pockets of wallets, and Europol is dealing with this. And if you can follow these transactions or monitor these transactions using the requirement of the legal requirement on identification of the users, so Europol using a cache number which is based on the mixturing system, replacement of crypto wallets or substitution of crypto wallets. In such, there are some countries where it's very hard to monitor the system. There are some legal prohibition, like in Japan, which plans in the near future prohibits such a currency, circulation of such a currency as Monero. And the chains are used for FPT, FATF requirements, and to identify those individuals who are trying to dodge taxation. And this system is highly employed in the United States. In the OECD, in the Financial Markets Committee, we are discussing two questions which are not clear so far: the cryptocurrencies which are not possible to identify a transaction, and crypto stock exchange. Is it because it is decentralized? Who is responsible? What is going on with respect to those transactions that are taking place in this stock exchange? So far, these questions are pending. Thank you very much. We are moving to another questions. Unfortunately, Federal Taxation Service deceived us. Not only we deceived her, but they didn't come up. Alexey Vladimirovich, I believe you will have to say something on their behalf. What can we tax from crypto assets? This is property. Yes, this is we can touch them. This is property, and depends on the kinds of transactions. Proceeding from the legal aspects, I would pick up C answer. It's clear that how the system works. Foreign currency is taken as an example. We have some tools denominated in foreign currencies. They are taxed in currency and in national currency. If you buy a bond, you pay a tax. If you just put currency on a deposit account, then you are not taxed. The same story if you have with the crypto bonds or cryptocurrencies. If you put it on the accounts, you are not paying taxes. So this is a combination of specific situation to specific realities and specific legislation. And on the other hand, how we can determine this in our legislation, which unfortunately is bogging down in attempts to cover the whole universe and even beyond. We believe that the approach would be in the following manner. From the taxation point of view, cryptocurrency is a currency. There was a direct prohibition for circulation, but this is a currency as it is. If you use cryptocurrency and you have profits, they should be taxed, and VAT and so on and so on. If the exchange rate changed, then it was proposed not to tax it. And we need to fix it in legislation. It depends on the decision of the legislators, and it's difficult to predict how it would turn. And cryptocurrency is a financial tool or security, or better say, currency. We regarded it as a currency. Now we, after first reading, we are regarding this. We're trying to determine financial assets and the cost of property should be taxed. I don't agree with that, but this is just the first reading, then it would come to deputies. We are not talking only about cryptocurrencies, we are talking about crypto assets and crypto tokens. These are tokens which appear in the ACO processor. And of course, they are quite close in a sense to the shares in the APO sense. They should be close to that. Even other questions regarding the emission issuance rights, they are different completely, but from a taxation point of view, they should be in the same. And in fact, I believe that we try to divide all these aspects. Remember, we have a draft law where tokens will identify as crypto assets with limited circulations. And
yes, open platforms could be used, but they were not fully available. And we tried to differentiate between tokens and other things, the ones that are used in the process of trading cryptocurrency. Tried to address that in the draft law, but after the first reading, unfortunately, the destiny of that law changed seriously, and well, we don't know what would happen to that law in the end. A person who changed that law, Vladimir, well, I also participated in the first round of discussions of that law, so I was from the very start of the process of preparing that law. Now I'm a little bit far from that, but in my professional activity, I had to take into account the positions of various agencies, in particular the Central Bank of Russia. And the draft law that's been prepared right now and hope is going to be adopted soon, there would be no problem with tax in that law. It would be treated very similar and non-documentary securities. And in terms of tax, probably the same principles would apply to cryptocurrency. Now, tokens, both actually, to put it in other words, put it in legal terms differently, but both are present and addressed in the law, but their use should be limited to closed platforms, closed blockchains, not open blockchains. Actually, one of the discussions that we had, and I was in favor of using open platforms actually during the discussion, because I said that would allow us to overcome the sanction rules. But the reply was that there was information that the CIA can open any platform or any anonymity. So no anonymity can be assured. That was the argument of the opposing side. I don't know. I don't deal with the secret services or CIA. But well, that's what the person told me, and it was like a weighty argument. So we decided to limit ourselves to closed platforms as a result. Now, taxing crypto instruments, had we legalized that quickly, like the initial intention was, then we discussed the tax should apply at entry and exit point, as you enter into cryptocurrency and exit. And the difference will create an income for a person, and that income should have been taxed. Plus, any business activity associated with that, it was suggested should be taxed as a business activity. If it's a small business, then simplified taxation system. If a big one, the way taxes applied to big companies. Nothing new was drawn there. Yes, thank you, Tatiana. Well, I agree with number 3. Answer number 3. I see the audience supports this position, but the questions themselves may be a little bit vague. Since you cannot touch it, it can be text. Answer number 1. I don't think the definition here is very good. Like Karl Marx once wrote about added value. Remember that it cannot be touched, he said, but this added value does exist. In that sense, cryptocurrency, for me, it's more of an element of the monetary system. Yes, you can consider it a property, but I'd rather call it currency, private money, and the transactions can be taxed if they're transactions denominated in those units. As for mining, for me, mining and income from by miners are similar to seigniorage that the central banks of all nations get from issuing money. So in this sense, number 3, yes, sometimes it should be taxed, but not necessarily always. Alexander, I have another follow-up question. If we consider it as property, when we change cryptocurrency to fiat currency, what happens? Depending on your skills at trading, the value of your portfolio could go up and could go down. And following the logic previously used, nothing should change. If it's a dollar or a euro or share, nothing happens. You buy at one exchange rate, sell at a different one. Well, if it's securities, then this change in the price of a security should be taxed. That's my opinion. I wanted that to be incorporated in the law, but that becomes dangerous. We consider it as a security, then you should tax all transactions. And for as long as it's transparent for some people, it may not be as transparent to the tax agency. As a result, problems can arise. Depending what property. You said real estate, well, real estate property, okay, but securities, are they property? Not? Well, according to the civil code, it is property. Securities are property. Well, you say property. Well, in the understanding of most people, it's real estate property, when you say, with some exclusions. There are for private individuals, companies, etc., with certain fine categorizations then. But there are other types of property. Well, like movable property, your car. Maybe you bought it 25 years ago, you sell it now. And if you sell it for a profit as a vintage car, then you will have to pay tax on the difference. Well, but for real estate properly, there was special tax regime towards certain problems, difficult situations. Won't go into that. That's at 3 years you have to wait before you resell real estate property. That's for real estate only. That doesn't should not apply to other forms of property. Well, the first distinction is whether that activity should be banned or allowed. If it's banned, the first branch in the decision tree, if it's banned, then there is no question about taxing this activity. But if we say yes, it should be allowed, and decided then this is a legally valid asset, then the question is how to define that asset. The tax will appear, but the question is what kind of tax applied to what. That could be all sorts of taxes that we can use for the purpose. If we define cryptocurrency as goods, then it's VAT that should apply. If we define it as a security or currency, then there could be options. Alexei mentioned that, but in the final run, if there's profit, if it's regular activity, there should be some tax. And coming back to mining, and that decision of the president that has to be complied with. Well, what the president says, he gave instructions actually to define that as entrepreneurial activity, and it would be logical then if it's entrepreneurial activity, then the profits or gains from mining should be taxed based on the status of a person. If it's a private entrepreneur, then would be one type of tax. If it's a legal entity, different tax would apply. But in those instructions from the president, that should be treated as a regular business activity, and the rate of the tax would only depend on the type of the business that is engaged in, that private or individual or company. Well, cryptocurrency can be used as a means of payment, and if you follow the logic that it's a currency, then the tax clear how to tax it. But what about tokens issued for ICOs? Some countries make a distinction by the nature of token. There are product tokens, as we know, sometimes something like a bonus program, and there are tokens that we just mentioned, similar to securities. Well, as you develop this draft law and maybe amendments to the tax code, do you make this distinction by the nature of a token? If you do, like last year, Israel made a note of explanation to the tax about how to pay VAT when tokens are issued for ICO and for a product token, VAT at the point of the obligation to pay the VAT. Well, the legal entity should will have that obligation when they use the token to procure goods or services. My question is: do we distinguish between the types of tokens and what would happen to VAT in the version of the draft law that we're going to have? Well, as I said, it's very similar to non-documentary securities. There are some differences, but close to that. There would be a right to income that we could get from a project for which the tokens have been issued under ICO, or the right to participate in the business that would be developed on the basis of the investment. As we agreed, there would be 3 laws issued together. The first main one would be changes to the civil code to capture the idea of digital rights, and it's not only financial rights. And the right on digital financial activity assets would apply to those, and probably the norms similarly to financial assets would apply. And there's nothing about product tokens in that law, but presumably later on such tokens would appear in regulations. There's a discussion actually already about these tokens from the standpoint of law, how to register those things, etc. And where we are coming to is to adopt a law in the near future on regulatory sandbox to test. Well, it's like a theoretical test. Experts, while computer simulations, etc., that would not go to the working environment. And the law that we're going to enact would allow within a region or a particular company or an industry to do a pilot project to test the use of these tokens. That's where we are moving. There is a proposal from the Russian Union of Industrialists and Entrepreneurs on using product tokens for the development of mineral resources. Well, so my answer is this: not in the current version of the law. We don't have product tokens there. But this year would be devoted to this particular thing. Well, there's a long-standing question. People would have, would ICOs be possible in Russia in the situation where we have no law yet? Well, if it's not banned, then it's allowed. That's my viewpoint. So the most popular answer is yeah, depending on the type of relationship, and more specifically, like in some countries done quite a long time ago, because the distortion of the tax base was a very high level of risk for countries, like money laundering. Yes, indeed, many countries thought quite a while ago that they should tax crypto assets in the absence of a specialized law or amendments to the tax codes. But there were explanations made on how to do that in the absence of specialized law for the typical transactions, direct taxes for mining and salary payment. Mining considered as an entrepreneurial activity in many countries, but deductions treated differently by different countries, like tax service of United Kingdom recently issued the explanations that electricity expenditures should not be deduced, and that is allowed to be done in the United States. If you get payment of salary in cryptocurrency, doesn't mean that you cannot pay taxes. Like in the United States, they apply the tax regime that apply to private sole proprietors. While VAT, no VAT, two approaches them. United States consider cryptocurrency as property there and treat it in that way. And what is closer to our legal system, European Union, they treat the story differently. Well, our currency transaction, exchanging bitcoins to Swedish kronas, based on one analysis of one transaction, they made a decision in the European Union. If you exchange a cryptocurrency to normal currency, it is treated as a forex transaction, and that would be regulated by VAT directive, but VAT should be excluded because it doesn't apply to forex transactions. That's what we have in other countries. Yes, we raised this question. Well, would have wanted to get answers from the tax agency, but they said they cannot provide the explanations until the law is adopted. But there's court practice. Normally, the courts, the tax service requires tax will be paid on VAT, mainly on profit rather than VAT. And the court practice is there already. We are not, our legal system not based on precedents, but still court practice important for further decisions. Moreover, there was a case, and there was a divorce case. And the husband says that cryptocurrency should not be included in the separation of joint property, but the court ruled that that should be included. When we discussed that with the lawyer who was on the side of the wife in that divorce case, and the lawyer told me, well, you should pass that law and amendments to the civil code, or we don't get our money. And I said, don't hurry, let the court decide. Back then, at that time, there was a letter from the Ministry of Finance saying that cryptocurrency had economic essence. So I advised that lawyer, please use that letter as your argument in court. That I'm saying this to stress that we do have to place at least some trust in the court practice. Actual cases, we were the lawyers who were against harsh definitions of all these things, and that was 3 years ago, because very difficult to clearly define, because tokens is property rights, but not only property rights. Cryptocurrency could be, yes, but the United States, because they have sales tax, and they treat it as barter transaction. For them, it's property. European Union says, for us, it's currency, for its foreign exchange transactions. No VAT, only commission for a forex transaction. In that sense, court practice helps a lot, shows the attitude of the market to it. The next question, maybe somewhat narrow, but that might be very interesting to the businesses. Other countries that have clearly defined how to account for crypto assets from the accounting standpoint, and which of the countries? United States, Canada, France, Kazakhstan, Belarus, Japan. Well, I think three rather than anything else. I don't know about Japan, but Belarus, yes, that was one of the countries in the Euro-Asian Economic Union. They have regulation of cryptocurrency. There's a decree of the president. It comes from December 17 or somewhere like that. Where everything is described. What is cryptocurrency? What's the token, and how to do financial accounts of those. In June of that year, in a series of events that we had in Eurasian Economic Commission, in all countries of the Eurasian Economic Union on cryptocurrency. That was one of the events, was in the high technology platform of Belarus. So my answer is probably Belarus and Japan. What does the Ministry of Finance think about that? Well, I have to answer so many questions on behalf of Ministry of Finance, but still, I think number 3. Especially after the previous answer to the question was quite clear and straightforward. Now I have a question and maybe even a request, something very important for the businesses on how to account for that. It's Belarus, France, and Japan, the few countries that now have clear accounting rules on how to treat tokens and which article in the book of accounts that they should be included. It really doesn't go to from the authorities quite often. The businesses, the companies ask this question. They don't know how to show that in the balance sheet, what code, etc., what line item. The ministry can provide explanations on how to treat from this accounting standpoint. And we actually have a draft explanation that the Ministry of Finance is considering, and we can share that with you. Very good that you worked on that. I'm not responsible for accounting practice. Very good that you conducted that work. But generally speaking, the department I'm in charge of gets a dozen thousand letters from people every year. Based on that, we see what people are interested in. What is most common question from the people about cryptocurrencies, whether they're allowed or not. And second, paid in a cafe, a card connected to an account in cryptocurrency outside the Russian Federation. Initially, they wanted to start proceedings against the person because that was payment which was not made in rubles. But later it turned out that the transaction was like that, from the cryptocurrency would transfer to foreign currency, then to Russian currency. As a result, the cafe got rubles, not cryptocurrency. So it does work for crypto cards, and we keep on getting these questions, in particular how to organize the ICOs in the right way. As for accounting rules, well, there were not many questions about the accounting rules. Strange that, well, you feel that that's a very big matter for the companies. Not in our book. Well, there's a cartoon with two old ladies sitting on a bench, and there's a big data sign on the other side of the bench. Well, you have a question. Yes, thank you. well, representing business, small business, plans to work in that area and get income in cryptocurrency. Why do we want to do it? And why are we doing all of these things, cryptocurrency? For small business, that reduces transactional costs very much. Very easy to create a business based on blockchain. You don't need service administrators. You don't have to support your own IT system. You just incorporate your IT logic, etc. So for smaller companies, it's extremely important to have this law regulating this activity to make sure the law allows the companies to stay within blockchains in their operational activity. They don't have to extract logs transactions from blockchains and bring that to the tax service. That would lose the whole benefit of working in blockchain. That would today, by getting an income in cryptocurrency, if we want to fully legalize it, in that case, we would have to spend 10 times more money to simply hire chief accountant, to show all of that in our books, etc. And that would cost 10 times as much as we're paying right now. So the effect of this technology can be used by us in full only if all operational activity can stay in blockchain within that centralized network. That's number one. And second, I would want to add very much to the anonymous currencies. There's a technology behind those currencies, which in terms of effect very close to the appearance of jet engines in aviation. There's anonymous transaction privacy. It's a small bonus. But behind that technology, that's a possibility of making huge computations using very small resources. And if we try to kill these technologies in this country, then we'll stop developing technologically, because the future is with these technologies. Potentially huge computing resources the country can get access to if we use this technology, and that will translate in new medicines, big data, all the modeling simulations, etc., etc. So privacy and anonymous transactions, don't try to stop those. Don't try to over-regulate those. And there's, well, in all those anonymity protocols, if there's a country all countries trust, then the implementation of that technology would be facilitated 100 times if there's a trusted party for everybody, and the government is an ideal candidate for that. The government can help citizens protect from others, from espionage, from loss of data, retaining full control over financial instruments, getting all the required information automatically, get taxes paid. All of that can be implemented, so don't be too harsh on anonymous payments, please. And while the main position is to try to keep all operational activity within blockchain, because everything is available out of the box with blockchain, the reporting tools, anonymity, etc., etc. I have a question and a comment. First of all, in the lobby, so top management of Ross Monitoring Agency, and very interested in your position, in their position on anonymity. But actually, it's them who are dealing with that. Ross Monitoring. Actually, we invited them. Oh, there they are. There they are. They're in the audience. Let's invite them to this table, because you're an important stakeholder to us. Well, I just noticed the person. Yes, financial espionage, that's what they're doing. Well, then a question. Sergey, to you. A trusted party thing. Maybe I'm wrong then, but my idea is I think it's a profanity. Full distortion of the idea of a blockchain. What is a trusted party? Well, it's data center. There's central bank with a clearing center. There's a stock exchange with their own centers. Why do we have to multiply all these things? Build those superstructures of the data center. What is a data center? It's a final version of the truth, knowing everything about everybody. What does it mean? What remove a depository of the bank? Well, they would give you a paper confirming that you own a certain asset. If you create a blockchain trusted party at the center, then you'll get the disadvantages that have all digitalized system, and you don't get the benefits. And the benefits are cheapness and quickness of reaction. Well, my comment was mainly on the technical side of it. Well, those pure anonymity system like Monero, very difficult to build, and they would not be able to be regulated. You cannot trace them, monitor them, etc., etc. And the CI will not be able to do anything except direct attack on the people involved. As for the trusted party, it's it would facilitate the process technically. The government can act in that sense. It's not a data center. It's the government who would issue the procedure and make all people comply with it. Because you trust me, you will be able to hold anonymous transactions between yourselves. They would be transparent to us as government, but not to you. The business agents would not be able to see themselves. Government sees everything. Well, have a look. We suggest the following option for ICO.
We see such a notion as public declaration, which says what should be done within this certain contract. We use electronic signature, and we use it as a depository where this file is stored. And in a case of a conflict, everything is published out and used in litigation. It's clear. But when on a daily basis we worked otherwise, I don't understand how can we do it. So a state like a crypto ruble could serve as a validator of these transactions, and everybody was asking, please open the information or disclose this information showing the specific chain of transaction, and it could be proven without going outside or without going from a blockchain. It could be added that if this decision with the trusted party would be implemented at the governmental level, it would be good if this register was the governmental structure. It would be good for a blockchain structure. I will give the floor to my colleague from Rosmonitoring. Thank you very much, Alexei, for identifying my presence here in this room. So this is the intelligence information. Probably you invited to this meeting our deputy head of our service. He's mostly involved in these discussions, and he is now attending the FATF, one of the FATF meeting, which is dealing with this practically the same issues. I must say that, of course, we should move along the global trends, because this problem is of global nature, but we are not financial technologists. And probably we are looking from our angle of view how it would be done legislatively. Of course, we see and try to get involved in assisting to our legislators. But the pilot project, which was mentioned here, which is not mostly dealing with digital identifications, which is now tested by several banks. Probably it could provide a sort of initial information for further development of this information of identification, which would be on the one hand an independent element which would be used by cryptocurrencies elements, but at the same time it could be developed using those processes employed by other national entities, because this process is boundless. Our interaction with the Rosfin monitoring, when you ask you, do you see any threats of flow or capital flow in cryptocurrencies? The answer was no, because a lot we see in real money flight. A lot was said about the trusted party, which saying that government could serve as a trusted party. We're trying to use elements of new economy to incorporate them in our traditional economy. This is big data, and once we see a problem, let's turn to the state, and state would be blamed for that if we fail. This is a very interesting approach. Even business, which is dealing with these things, so they use it as attributes of a traditional economy. Cryptocurrencies are attributes of digital economy, and digital economy is not only something in digital, but a new economic approaches or patterns which are being formed only just right now, and they would have a new role of the state, new role of the central banks, private business, and so on and so forth. And in this regard, we need to focus on that, because the other thing is very simple. Why do we need cryptocurrencies if we address all these issues in the older manner, looking or approaching them from traditional points of view? Thank you. Now let's move to the right answer. So accounting, the right answer. Belarus was the first country which used this, and the second country was Japan. We don't have much time. Let's move to another question. How to mitigate risks of violation of investors' rights in ICOs? Two options: use legislation on securities, current legislation, or to adopt specialized regulation for ICOs. Any ideas? And audience, please choose the right answer. You looking at me? Okay, I will start. The best way to kill ICOs forever is just to apply the whole bunch of the legislation to them. I believe ICOs is a crowdfunding, how it appeared. Starting from 2003, the world has started to overburden these processes, and the outcome started to get lower, reducing efficiency. This is a classical situation when regulator stiffen the bolts and kill the idea. Unfortunately, we have the same situation. Crowdfunding, sometimes, mainly it is ICOs. ICO, this is a response to a system, to a very protective approach by the regulators. So we need to apply some elements of securities, but as I said, in my opinion, it should be a public declaration or a certain site which has a declaration posted on this site with electronic signature, and a depository of this declaration. So this minimum set of things or at least this tiny white paper, so to say. It, it is not my invention. I just read some lectures of the US company which is working in Russia, and they advised to have a voluntary declaration registered with notary. Otherwise, and Sergey talked about this, you will fail to prove something to anybody. This is what we need to regulate. Secondly, the way of circulation, like securities. Two things. First, we need to split quals and non-quals in terms of purchases of tokens. Why? Why do we need to limit? Why do we need this? To limit them? So I don't know what would be the draft law after the second reading, but now we are moving to a second draft law that from a certain amount of tokens only qualified investors could purchase them. Yesterday I received citizens. I will do it on a monthly basis. And the main token during these meetings, I was presented financial products. I bought it, but I got nothing, and I deeply convinced. We make some amendments into the investment loan investments, and I believe that people, let's say, ideally, when they are financially literate, then the situation would be better. But now people are not so financially literally, and sometimes they sign the things that result in their poverty or insolvency. So this is a currency mortgage, for example. States spent to compensate spent millions to compensate the losses for the people who signed something they didn't understand. That is why we need to prevent such a situation when people are signing something without clear knowledge of what they are signing. It's like it's like a statistics of OECD. ICO is funding of the small business, and it's around 50%. But the world doesn't limit the purchase of tokens. In some countries, I saw some limitations. There is a patriarch or old version approach. We will tell you when you can do independently and when you cannot act independently. We can tell them about crowdfunding platforms where there are some limitations and requirements. But if we introduce some standards on white papers and should control how ICOs would look like for consumers, that would result to additional criteria when people can buy additional amount of tokens. And Anatoly Gennadievich, from what amount these requirements would apply? I mean, the purchase through qualified investors. There is such a notion, classical notion in economy, as Alfred Johnson, where he showed that if you have a collective investment, in average you will get the S in average in the market. That proves the theory that the managing company cannot assure the higher profits, but on the other hand, it prevents you from the systematic losses. So hundreds of ICOs would be bought. It's like mortgage papers. I'm prepared to buy a mortgage paper, but I'm not prepared to give it to some individual who wants to buy some mortgage. So we see here the shift of risks between various stakeholders, and correct assessment of the products is more reliable, more secure, and I don't see any problems here. Anatoly Gennadievich. First of all, I would like to say that everything which was told by Alexei Vladimirovich from a point of view of the process of issuance of tokens and their circulation is spelled out in the law on digital financial assets and in the law on regulation of the investment platforms. And from this point of view, the law on crowdfunding is a little bit wider. You can attract additional assets without blockchain, but if we talk about restrictions of the unqualified investments, we have such a provisions. This is a privilege of the central bank, saying that central bank can establish requirements for investors in attracting digital financial assets. Before we had 100 for one thousand for one project and 600,000 in aggregate for 1 year. Now you can put 600,000 in 10 projects, or you can put this amount into only one project. Why do we need to limit them? I also had meetings with ordinary people. They turned to us, to the State Duma, on the issues or regarding purchases of or acquiring something they do not understand fully, and they put the blame on the state always, because it is the state who allowed to issue these financial assets, and as a result these people blame the state that they go bankrupt. And this is a problem, and I, as a person who faces these problems on a daily basis, we need to protect our citizens. Well, it's limitation of the limited investors. Shall it be spelled out in the legislation? I believe this is a secondary issue. The main thing in this story is the time and flexibility of the adoption of these decisions. We shouldn't spend a year to develop approaches to such regulation. I work in the same financial organization, and colleagues would like to be innovative, and they would like to produce a new product which is needed in the market, and they would like to do it in 2 weeks. We need to adopt a law on a regulatory sandbox. We could provide some limitations. It cannot be safe against everything, like gypsies sold bitcoins from hands, out of the pocket, like jokes. Of course, that can, for us at least politically, we would be on the safe side. No one can put the blame on the Ministry of Finance, on the government, saying that we allowed new financial pyramids and people were lured into these financial pyramids. I don't believe that it could be a problem. If we see no fraudulent activities with that, and people feel a need to invest into these products, then okay, we could expand these limits or probably remove it at all. Now we don't have a practice because we have nothing to discuss. Is it difficult to predict whether people get drawn in the pool or not? Even we still don't have water in this pool, swimming pool. That is why all our deliberations here, I don't believe we need to make a politically correct decision mentioned by my colleagues, and they would be responsible for this decision, and after that we could get them solved. The problems faced by Russia is that we introduce limitation, and then it is very difficult to remove these limitations. So to think about such things of the fifth and sixth level should be based on systematic basis. I wouldn't agree with my colleagues regarding the damage to the citizens. History of our country is quite specific, and main financial assets were inflicted on our citizens because of the history of our country. All our financial reforms of 1991, currency crisis of 1998, they resulted in these numerous tragedies when people sold apartments, cars, put money on their accounts, and then it turned out that they don't have anything because of the devaluation. It doesn't mean that we should say our citizens get out of the system. People in my countries, I believe, could decide independently, but we need to warn them, like on tobacco boxes, saying that smoking can kill you. We can say in our legislation those things, a number of requirements for ICOs, so that citizens who invest in them should realize the risks, realize that this is a highly risk situation, operation, and if they lose something, then it's up to them to blame. It should be their own responsibility, and I don't believe we should have some limitations on that. Thank you very much. And our last question, following the logics. ICOs, is it a new method of funding of startups? No, practically all ICOs is a fraudulent activities. IOTA, what your organization believe about this, especially in the report which was published yesterday? The experience of more than 20 countries was analyzed, and what international community thinks about this. And after that, we will produce the results of these answers. We have a simultaneous translation.
So at the OECD, we have, do I have the, yesterday we published a report about initial coin offerings. This report is publicly available online. You have to search for initial coin offerings for SME financing at the OECD website. It's the result of the discussions of the OECD Committee on Financial Markets back in October 2018. Both Ivan and Antonina have provided their input and participated in that discussion, so thank you for that as well. In this report, we examined the benefits and the risks of initial coin offerings for small businesses and for the investors. And we took a more practical and analytical standpoint when it comes to ICO processes by looking at the process and all its steps, and by also discussing how do initial coin offerings compare against traditional ways of raising finance for small businesses, which is venture capital, small IPOs, and crowdfunding, which was mentioned many times in the discussion. I'm mindful of the time, so I will skip some of the details of the presentation. I will just say that we have seen a peak in the activity in January 2018, and since then we see much lower number of larger sized issuances. If we do not look at the pro forma basis, excluding the Telegram and the EOS ICOs, we think that the activity is still very high, but on a pro forma basis there is a normalization, and of course at the second half of 2018 there has been also the collapse of the prices of the crypto assets. So when we look at the ICO process, we know that the main benefit is the creation of value through efficiency gains that are allowed by the use of the blockchain. We have very, very high speed of execution, we have lower cost, lean processes, and here we have one small comparison of an IPO against an ICO, where we see the ICO can be done in less than 6 months, when 6 months is not even enough for the planning phase of an IPO. In the report we have a full table comparing ICOs to IPOs for those who are interested. I will skip this one, which is the rights that can be attached to tokens issued in ICOs. I will just say that they are very different depending on the transaction. There is full flexibility, and the companies decide which rights to attribute depending on the intended purpose of the token issuance. So I will go directly to the rest of the benefits. So we've talked about speed of execution, we've talked about cost efficiencies. There is no intermediary as in other forms of risk capital financing. There is direct access for the company to an unlimited pool of investors. Many people talk about democratization of SME financing and unrestricted access of retail investors who previously could not get hold of SME risk, now can hold SME risk as well. The companies can raise financing without necessarily giving away ownership in their company, and this is one of the main reasons why companies did not go in the market to raise financing, because they don't want to be diluted. This is something that is addressed with ICOs. Liquidity is very important. You can have near immediate liquidity when, for example, for venture capital, you have very long holding periods and absence of any liquidity. And the most important differentiating factor of ICOs versus other forms of financing is found in the network effects, and this we find that is little discussed in general. So by the mere participation of token holders by subscribing in an ICO, they create and form a network. And the positive externalities that are found in any network, which are called network effects, allow for the creation and monetization of value, and which is really perhaps the most important breakthrough of raising financing through an ICO. Then at the same time, we have looked at red flags. I will not go through the whole process. You know, basically there is a founding team with a concept. They announce their intention to raise financing in the market. They come out with a white paper, perhaps some technical paper, perhaps some terms and conditions. Then they have the option of selling to cornerstone investors or to some insiders before the actual offering. Then they market the offering, they issue the tokens, and then they go ahead with building the platform. So what are the red flags throughout the process? First of all, in many unregulated ICOs, the company is not even incorporated into a legal entity. So it's just some founders who announce their intention to raise financing, and there is no legal entity backing this offering. The offering is, in most cases, about something that is at concept stage. There is not even a prototype for the service or the product that will be developed. And the founders do not put personal financial risk in most of the cases. So they don't have any skin in the game, as we say, and therefore they are not really engaged in delivering the product. They can just get the money and cash out and never deliver the project. So we see there are a lot of misalignments of interest in unregulated ICOs. At the pre-sale stage, we see that some tokens are offered at very heavy discounts when they carry the exact same risk that token holders will subscribe to at the later stage. So we see there is again some sort of conflicts of interest. Transparency is a big issue. The white papers are not standardized. In most jurisdictions, they are not even vetted. There is no auditing. Information asymmetries are huge. Then for the listing of the tokens, the listing is not always guaranteed. It has become very expensive in some cases to list a token that the company has issued in the ICO. And even when listed, the volatility is very high. The counterparty risks when dealing with trading platforms that are unregulated themselves are also very high. And a very important point is that something that we intuitively thought of before, but now there is academic evidence, that the price of tokens issued in ICOs carry some systematic risk that is correlated to the Bitcoin. So there is non-idiosyncratic risk, which means that basically there is nothing linking the company's product or services to the Bitcoin, but the pricing of the token itself is correlated to the Bitcoin. Then in terms of launching the service or the product, we have a lot of operational risks that are related to the underlying distributed ledger technologies, which are still new. We have hacking risk, cyber risk. We have problems with uncertainty of settlement finality. And as I mentioned in the beginning, we have a lot of potential misalignments of interests for companies who did not have personal financial risk at stake, who do not have lockup periods, so the entrepreneur can at any point in time just cash out or manipulate the price of the token offered and then pump and dump, as we say. The risks are also found for the subscribers. And these are also practical implications that we don't discuss enough in our view. For example, most of the ICO offerings and the tokens that result from them do not fit into the traditional investment paradigm. What does this mean? It means that we cannot apply regular corporate finance theory in order to evaluate a token. This is because of the way the value is created in the system and the way it's attributed between the different participants. This makes valuation very difficult, so in essence, you are asking someone to invest his money in something that he cannot properly evaluate and therefore price. The second important issue is the accounting issue that you have discussed already, and it means that you cannot have a way to follow up on the performance of your investment that is in some sort standardized for the entire investment community. There is risk of dilution in case of uncapped sales where the issuer has not given a full schedule of the issuance, and then any new token issuance erodes the value of the tokens that are already held by token holders. We have a lot of problems with conflicts of interest potentially, as mentioned before. There is also the practice of free allocation of tokens to the entrepreneurs when they take no personal financial risk. The absence of lockup periods is also very important. The allocation of the value within the network is difficult given that tokens in most cases provide both a way to access a service or a product and also some sort of participation in the appreciation of the value and of the company itself. So it's difficult to split those two. In terms of corporate governance, anything that is on the distributed ledger technology has, by definition, problems with governance, given the decentralized nature of the whole network. there are very limited structures to hold accountable a company as token holders. We've talked about financial literacy skills, very important, and there is a second level that goes to the technical skills for people who want to subscribe to an ICO offering because they need to have some basic understanding of how to use something that is on the blockchain. For example, subscribers who lose the private key just basically lose the entire investment. So if someone is not really capable of dealing with the blockchain, there are additional risks. Risks for the issuers as well, because the issuer will need to predefine the amount of financing he needs for his venture while he is still at the concept stage. So there is a trade-off between understanding exactly with accuracy how much money I will need for the next 3 to 5 years, so I don't know how much it will take for me to launch the product from concept stage, or to go back to the market and request more financing with an additional token issuance, but if that happens, then I dilute the existing token holders and they will be unhappy. When the token is both a way of enjoying a product or a service on the blockchain and also is being traded on the secondary market, it means that the token's value will move on a freely traded basis. What does this mean for me as an issuer? It means that I will no longer be able to price my product as I wish, because the price of my product will be freely tradable and defined by market forces. We've talked about the dichotomy in the value attribution between token holders and owners in the absence of ownership rights. This will also be an issue when the company wants at a later stage to raise equity or debt. How will the value be split between the token holders and the next round of shareholders? We have extreme volatility, and we've talked about the correlation to the Bitcoin. Again, there is an increased amount of technical skills required and risks that are taken on in terms of operation on a distributed ledger technology basis. All the risks that we have identified, or at least most of them, are linked to the uncertainty that exists in many jurisdictions about the regulatory and supervisory framework of initial coin offerings and crypto asset markets in general. So what is important to summarize here is that regulation is not just about how will we classify the token, how will we put it in the how will we put the specific offering under a regulatory framework, but it also has to do with the entire crypto asset ecosystem. So we have to look at the trading platforms, we have to look at the exchanges, we have to see whether the issuer can actually get banking services or not. And the second level of regulation that is somehow not discussed enough to date is the regulation applying to the technology that underpins ICOs. So we may define well the for some jurisdictions the framework applying to the offering itself, but what about the underpinning technology? And one very good example about that is how do we regulate smart contracts? Are smart contracts legally enforceable? Does private contract law apply? What happens if there is an issue with the coding in a smart contract? Can the investor have recourse? And the third level that is important about regulation has to do with cross-border regulation. Given the very nature of ICO offerings, which is global, we have seen an amazing amount of regulatory arbitrage taking place. So we believe at the OECD that there is a need of some cross-border level of regulation to allow for those regulatory arbitrage opportunities to be extinct. As far as anti-money laundering and CFT are concerned, the FATF in October 2018 has issued guidance that says that virtual assets and providers of those are included in the recommendations and in the glossary, and ongoing meetings are defining further this, but it is important to note that ICO offering providers are now included under these FATF recommendations and glossary. Investor protection and financial consumer protection is very important. We have seen that there are a lot of information asymmetries, there is lack of transparency, the risks to investors participating, particularly for the retail investors, are very high. There is limited right for the investor to obtain redress and compensation if the offering does not fall under a clear regulatory and supervisory framework. We have discussed valuation, very important, pricing, accounting standards. Again, we have seen that the Big Four and the IFRS are holding discussions to see how we can have some more harmonized framework for the accounting standards. Conflicts of interest, very important to note them throughout the process so as to be able to protect investors against them. I will skip this, mindful of time. Two things that I want to mention to conclude. The first one is that I've mentioned all the benefits of initial coin offerings. But something that has to be told is that those benefits can only be realized under certain conditions and with specific caveats, one of them being the clear regulatory and supervisory frameworks. The second thing is that ICOs are somehow marketed as the solution for every single business. We believe that this is not the case, and there has to be a differentiation between those companies that have a strong business rationale for the use of the blockchain itself. If the company does not have a strong reason to use the blockchain, then the ICO does not make sense in our view, because there will not be the creation and the monetization of network effects. And in the absence of network effects, we don't see a lot of benefit in going through the entire process of raising funds through the distributed ledger technologies. So we need to really clarify that ICOs can be beneficial under certain conditions and with caveats, but they are not the right solution for all projects. And there should be a differentiation between blockchain-enabled projects where network effects can be realized and the rest. And as I mentioned already, clarity in the regulatory and supervisory framework is the stepping stone for the safer use of ICOs. We need coordination on a global basis and regional, I guess, in your case, to prevent regulatory arbitrage. We have talked about AML and CFT, importance of enhanced investor protection, and then we have a lot of low-hanging fruits such as transparency. We need to have more efforts of financial education, as was mentioned by the Minister, standardized disclosure requirements, and importantly, we believe that there should be elements of proportionality when it comes to small businesses in the application of regulation to them, in the same way that there is proportionality in some jurisdictions for small IPOs or for crowdfunding. Thank you. Any questions, please let me know.
Thank you. Before Yota presented, there was a question what an ICO is. Well, Yota addressed that, and well, it's a way to get funding for startups. When we talk to businesses, initially it will be like a sugar factory or people mining silver in Karelia. Everybody wanted to do an ICO. Indeed, ICO is an IT business, though, and it's more logical for them. And our final question here to the business What hampers the development of crypto business in Russia? No definitions in the civil code, uncertainty on the taxation, or nothing interferes with the development of this business in Russia. Andrei, Joyce Company. Well, I have an opportunity to ask a question from the regulation, then Peter and Pavel. Well, some of the questions I've heard answers to already, and I'm happy to hear that. But first of all, the question about putting on the balance sheet, that's an important thing. If we have the laws passed, but those procedures are not in the laws, then as Sergey has said, either business going to have high costs, and it would be a matter of profitability, that would push business out of Russia into foreign countries. And the second thing I was happy to hear today is about the sandbox. Yes, there's a sandbox of the central bank. Very difficult to get there, though. We are making this attempt so far unsuccessful. But when we kept the law, that would help projects and help regions and the country and the economy of the country as a whole. Well, within the digital economy blockchain project, cryptocurrency. Now, why are we talking about ICOs here? And actually, statistics, Russia is number 2 country in the world in the number of projects in blockchain and cryptocurrency projects. It was Ernst & Young, right, survey. And Russia was number 2 in the number of ICOs by residents, Russian residents, not on the territory of Russia. Exactly. But every second project in the world, there are Russian citizens in the team. Well, thank you. We like to be number 1 in the world. Well, there are 4 things we're number 1: rocket science, belly, and blockchain, and one more, I forget. And this shows the level of venture investment available inside the country, which is not much. Why was it sugar factories and mining mills that wanted to get ICOs? To get investment in Russia is very difficult, to get it otherwise. That was an interesting panel session this morning about Fintech. Why? Fintech. Why Fintech and banks? Because for startups, very difficult to get funding in the Russian Federation. They go to the bank and the bank would buy the whole project. So extremely important in Russia to create this environment which would help projects. Well, questions, Andrei. Do we have questions? Yes. When do you plan to have the law enacted? That's extremely important. A big impediment to the development of blockchain business in Russia. When the president made those instructions, we thought that would happen in June, then we hoped it's going to be September. Then FATF waited for their recommendations. They came about in the autumn. So when is the law going to be adopted? Well, I promised to have it enacted in July. I tried hard, but did not succeed. Well, actually, the market participated in drafting that law. We sought their advice in the process. Second, I think the draft law is not bad. Well, some people may not be fully happy with it, especially heads of association of cryptocurrency. But it is good. It would promote things in this country. When is going to be enacted? The documents have been delivered. First goes to administration of the president according to the procedure on digital assets. As a matter of principle, we know the decision going to be favorable. Some things have to be fine-tuned there, but monitoring, because FATF decision is here already, but that's a minor thing. On the civil code, as far as I understand, and Invest platform, we got the response just a few days ago. for as long as I know, I haven't seen those comments. Well, there are some disagreements with the draft law, but that would not take long to remove all those disagreements. So February, quite a realistic date when it's going to be enacted. I had hoped it's going to happen in January, but we could be quite confident that it would be done before the end of February. Can you, yes, briefly, and echoing the previous question about qualified investors and the volumes. Absolutely agree. Anatoly, Alexei, agree with you. Our platform people come to us as well, in particular are complaining about them being cheated by crypto funds. Well, Cashberry put it in the news and search field and read the history. We take ICO. I know many ICOs. Many broke up, many still going to. Interesting to see what's going to take off, really. And it's a great financial risks. Many fraudulent people all using that hype simply made money out of it and left. One person may not be a qualified investor, but had a lot of funds available. Well, you can help them somehow to bridge the gap between non-qualified investor and qualified investor. If it's a person, 600,000 rubles or so, not a big loss for such people, or most likely they're going to lose that. But what bridge the gap like that, I said, when I asked to prepare my own question. Well, I thought about international cooperation. I always keep on looking for foreign countries. So, and the president, and one of his comments in spring, said the cryptocurrency has potential to bypass financial sanctions that apply to Russia. But on the other hand, to be able to implement that, we need the law. Waiting for this law. And that fact that we still don't have the law, it's a bad story, especially if that's going to be a protracted situation. Well, that could be good law or bad law, but we need the law. For as long as we don't have the law, people will be leaving our jurisdiction, because you cannot play the game unless you know the rules of the game. So, my question is this now. Well, the regulator, the legislative authorities, are they as optimistic as ourselves about cryptocurrency tools to attract foreign investment into this country? Peter, what is your question again? In 9 minutes there's going to be another session starting in this room. So, executive, legislative authorities, are they optimistic or pessimistic about cryptocurrency being used as an instrument to attract foreign investment? In particular, our companies that are on the sanctions lists. Well, as I already said, the Russian Union of Industrialists and Entrepreneurs, they're big people, big companies, very important people, and they are now involved in the effort. They're not simple people, they're people with a lot of authority, very well informed, and they want foreign investors using this industry. So I'm normal. My opinion is normal. I will put it like this. And crypto ruble, now I believe a ruble used in blockchain would be crypto ruble. It's attached to the emission of a central bank, and evidently this unit would appear, and that would be another stage in the development of our currency system, human currency system. Thank you. One final question, please. Can I ask, before you finalize the loan, the digital financial activity assets, adjust the definition, please, because the first definition of the digital financial asset was, it says it property created with the use of a cryptographic encoding. If it's so, then it's not a complete definition. You then have to add electricity, computing technology, etc. and other ways. Or we can make it differently. Me as a business, I want to go ICO. I start a blockchain node where, well, it's an emission, 10,000 tokens, and I start software. But my token will then not comply with the definition of digital financial asset. And when a regulator comes to me with the questions, I'd say, I'm not the person to deal with because I don't have digital financial asset. So can we adjust that right now? If not, maybe next version of the draft. It's a completely different definition, actually. And I hope you will be satisfied with the definition once you see it. I can read it out, actually. Is it about the latest version of the law? Yeah. We have to complete the session. Thank you, everybody. Let me draw your attention to what the audience said. Uncertainty about business processes, that's the main thing. And transactions with the banks, these are the business processes that require regulation. Yuri Pripachkin, well, if you are able to retain the people here, yes. Well, just a few words of comment. Well, Tatiana made that presentation with a very important message about a new system that would not be connected to what we discussed here. And digital economy has two stories. First, implementation of digital technology in the analog economy, and the second story is crypto economy itself, digital economy associated with a new essence. And the new draft law that being discussed unfortunately fails to address the second question. So the answer is very simple to the question that was raised here. The law needed? No. But and once it's enacted, that would lead to nothing. We would continue working the way we did in the past. The legislation for the central bank and officials is something the businesses are not interested in. For as long as it happens like that, we will be leaving the country. Thank you.